May I please go? So I beg to mention item number 5, Lordship. Item number 5, Lordship.
Item number 5.
Yes, Lordship.
Okay.
Conducting counsel, Mr. A. Ahmed is out of station. Lord. A. Ahmed is out of station. Lord. He is the
Okay.
conducting counsel.
You are Mr.
W. Rahman.
On the prayer of Mr. W. Rahman, Learned Counsel, appearing for a petition, the case is passed over for the day, PP.
Lordship, I'm also praying for a date, Lordship. That can it be before 16, Lordship, any date, Lordship?
Please look.
Next week.
List the case on Spence.
Lordship, item number 7. Lordship may kindly be passed over for the day. I've been instructed that Ms. S.G. Borua is keeping unwell today.
Okay. Mr. J. Singh,
Jason, Lordship.
Learned Counsel, appearing on behalf of Ms. S.G. Borua, Learned Counsel for the petitioner, has sought an adjournment on the ground that Ms. Borua is indisposed. Full stop as sought for. List the case on.
As per my last convenience, number
Okay, he will
20.
PP.
Obliged.
In the list for motion, item 1. This thing was out of law.
Sir, in this case, a report was called for regarding the Zimma of the vehicle, madam. The vehicle first, it was rejected at the stage of investigation, madam.
Yes.
And thereafter, madam, the report has come that the case has also been succeeded now, madam.
Hmm.
And that is the report, at the latest report, madam. So, my lord, anything regarding confiscation or other thing, my lord, then I have to take the instruction, madam.
If the
Because-
charge is submitted, let us have the scan copy of the case record.
Lordship,
I think
because
because he was the registered owner.
he
of
was the
vehicle,
registered, that is not.
and he was the occupant,
occupant also,
and
madam.
there was a secret chamber.
Secret chamber also, madam.
Contraband was seized.
Yes, madam. That is why, as per Biswajit Roy, it was rejected earlier, madam.
Let us have the full record.
Lordship.
Yes, Mr. Counsel.
Yes. Yes, sir.
Your name, please.
Omar Farooq. O Farooq, Lordship. O
Louder, a bit louder.
O Farooq, Lordship.
O Farooq, okay. Heard Mr. O Farooq, Learned Counsel, appearing for the petitioner, Mr. M.P. Goswami, Learned Additional Public Prosecutor, for the respondent state. Do you have any copy of the report?
Yes, Lordship. Perhaps the original report is with your lordships.
Okay. What was the date? 10/6.
10
Hmm?
last date, yes.
Okay. But still, the court asked for another report. Upon receipt. Call for a report if any confiscation proceeding or a vehicle has been initiated.
Yes, that is not,
Okay.
yeah, madam.
Mr. Goswami, Learned Additional Public Prosecutor, has submitted, on instruction, that after investigation, a charge sheet has been submitted in connection with North Guwahati Police Station case number 162/2024. Right, any idea?
Lordship, it was CS number 21/25 dated 28/3/25.
28/3/2025.
madam.
CS number.
Lordship, if you lost, may I
Okay.
produce the report?
That is all.
Lordship.
That is the information only.
Yes, that is the information,
Okay.
madam.
As the matter would require consideration, let notice be issued. Notice is made returnable on particular day. Particular day did you?
5th September.
5th September. Let the scan copies of any PRC case number.
Yes, case number, madam. Lordship, order.
ZR case number is there.
GR case number is there, madam.
ZR case number 1468 within bracket K stroke 2024. Be called for.
Special Judge Kamrup Amin Gaon.
register judicial Court.
Lordship, I beg your apology, Lordship.
It has been charge-sheeted. We are asking for the scanned copies on a fixed date.
This is just come.
Okay, we should notice period. Do you need any copy? No.
Lordship,
And for respond number 2, not required, I think.
Lordship,
Are you?
I don't know.
Lordship,
You're calling for a scanned copies
Yes, scanned
since charge sheet has been submitted.
Lordship,
So you can represent both.
Lordship.
I asked Mr. Goswami. That the additional public prosecutor has represented both the respondents. Issuance of formal notice to the respondents are dispensed with. 5th September.
Lordship, can it be shorter date, Lordship? If September is too long.
Difficult.
18 or 19, Lordship, of
Not
this month,
possible.
Lordship, August. Because it's lying with the police station, Lordship. They have not applied for the
1st
confiscation.
September. 1st September.
I'm obliged, Lordship.
Item 2.
Yeah, please, your lordship. This is concurrent findings, lordship,
Hmm.
for below. Convicted the petitioner under
Concurrent finding.
yes, lordship. 2
So
months and fine of rupees.
what is the trial court?
Yes, lordship. Trial court judgment, your lordship will find page number 15, lordship.
Is number 15.
15, lordship. Yes. NIA, lordship.
NI.
Yes, yes, lordship.
What is the imposition of fine?
Yes, fine of
6
rupees.
lakhs.
6 lakhs, lordship.
6 lakh. Imprisonment 3 months.
Yes, lordship.
Then judgment of
Then
appellate
default,
court.
lordship, 1 month, lordship. In this case, what happened, lordship, statutory notice also not served to the
But
petitioner.
2 trial courts have reached concurrent finding of fact.
Yes, yes, lordship.
Decision are final, rightly held. So everything has been affirmed,
Yes, lordship.
right?
Right.
So
Yes, lordship. The basic findings, lordship, lordship will find page number.
so at
22.
this stage, we will not go into the finding. What is the law?
Law, lordship, actually, who has deposit
Hmm.
rupees of 20%.
So what is the total check amount?
Total check amounts, lordship, 3,50,000, lordship.
Fine is 6 lakh.
Yes, lordship.
So if you want suspension of the sentence, then you
Yes.
have to deposit something,
Yes, lordship. Yes, yes.
25%. Within,
Can
within.
be 10%, lordship.
No, that statute
least.
says 25%. What do you do for your occupation?
Because lordship, I'm housewife, lordship.
Huh?
I'm housewife, the old age, ready, lordship. So your lordship kindly 10%, then
No.
it will be,
No, you have fought up to this stage. The deposit I am giving you 60 days time before the registry.
it can be on 15% or 10%, lordship. It is my humble submission before this.
Then
board,
time
lordship.
period will be shorter. Okay,
Okay.
20% within 45 days.
Yes, lordship.
Heard, Mr.
R. Borua, lordship.
R. Borua, then counsel for the petitioner. And Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, State of Assam. This criminal revision petition under section 442, read with section 438 of the Bharatiya Nagarik Suraksha Sanhita 2023 is preferred to assail a judgment and order dated 28/5/2025 passed by the Court of Learned Additional Sessions Judge within bracket FTC Unitpur at Tejpur Appellate Court page 36, in criminal appeal number 21 of 2022, whereby the appellate court, while dismissing the criminal appeal preferred by the petitioner, comma, has affirmed a judgment and order dated twelve 10/2022 of conviction and sentence passed by the Court of Learned Judicial Magistrate, First Class Sunitpur at Tejpur Trial Court, page 19. In NI case number 59 of 2012, full stop. The trial court finding the petitioner, who was the accused in NI case number 59/2012, comma, guilty of the offense under section 138, comma, Negotiable Instrument Act, has sentenced the accused petitioner to undergo rigorous imprisonment for 3 months and to pay a fine of rupees 6 lakh, comma, in default of payment of fine, comma, to undergo rigorous imprisonment for another 1 month. Full stop. There is I also.
Yes, Lordship.
Okay. The criminal revision petition is admitted subject to the condition, is admitted for hearing. Full stop. Now, I have gone through the grounds urged in that instant criminal revision petition. The criminal revision petition is admitted for hearing. The case records of so-and-so case number and so-and-so criminal appeal number so-and-so be called for. Issue notice returnable in 4 weeks. The petitioner, as Mr. Lusami has appeared and accepted, response number 1. The petitioner shall take steps for service of notice upon the response number 2 by registered post as well as by usual process within 3 working days from today. Post of heard the learned counsel for the parties on the interim prayer and on the accompanying interlocutory application, i.e. criminal 777/2025. Post of learned counsel for the petition has submitted that it was deemed service or what? You
Yes,
said notice.
Lordship.
What is the lacuna in the service of notice?
Service of notice under section 138, Lordship, they have not served properly to
Where is that?
petitioner. Lordship, in the findings of the court, Lordship, your Lordship will find page number 25, Lordship.
25.
Page number 25, para, Lordship. 16, Lordship, may I read, Lordship? PW1 in the cross-examination clearly admits that the signature of the accused now exhibit number 2 and 7 differs. From the exhibit 7, evidence given by the PW1 and the statement of the accused, it may be presumed that the accused did not receive any legal notice. This is the finding of the learned trial court.
The petitioner, learned counsel for the petitioner has contended that there was no service of statutory demand notice. First, having had the learned counsel for the parties, this court is of the considered view that till disposal of the instant criminal revision petition, comma, the execution of the sentence, the remaining part of the execution of the sentence passed against the petitioner can be suspended, subject to the condition that the petitioner deposits 20% of the fine amount of rupees 6 lakh, that is, comma, how much will be? 1,20,000 before the registry within a period of 45 days or 6 weeks. It will require issue notice returnable 6 weeks. Post op. It is accordingly ordered that subject to deposit of 1,20,000 by the petitioner before the registry within a period of 6 weeks from today, comma, the remaining part of the sentence passed against the petitioner. The execution of the remaining part of the sentence passed against the petitioner shall remain suspended till disposal of the instant criminal revision petition. It is further ordered that the petitioner shall be allowed to go on bail on a bail of rupees, on a bail bond subject to 10,000 with one suitable like amount to the satisfaction of the trial court. Post up on the returnable date, comma, the petitioner shall place the trace document evidence as regards deposit of the amount of rupees 1 lakh before the registry within the stipulated period. Post up. Further, till the disposal and further interim order. A continuation of the interim order will be considered on the basis of the evidence to be submitted by the petitioner regarding deposit of the sum of rupees so and so on the returnable date.
15/9.
Your deposit receipt also, yes,
1 lakh lordship. 1,20,000 lordship. Deep log lights.
in view of the order passed in the accompanying criminal revision petition number to the today, the interlocutory application stands accordingly disposed of.
Deep log lights.
Item 3.
Applicable.
Yes,
My lord, we have basically challenging the.
125.
Yes, my lord.
What was final order or
The
interim?
final order, my lord.
Huh? Final order.
Final order, my lord. So basically.
How much?
Yes, my lord.
What is that order?
So the impugn order starts from, my lord. 76, my lord. 82, and last page is like 2, my lord. So basically, my lord, we have
It
challenging.
is, 2 wife, 5,000, minor children, 2,000 each.
Yes.
Reasonable,
It's, my lord, it is-
absolutely reasonable.
My lord, so the basic facts of the case is that, my lord. So the learned trial court granted the maintenance amount to the extent of rupees 9,000 without assigning and without going to my income, and passed the said in.
What do you do for a living?
Yes, my lord.
What do you do for a living?
My lord, basically, I'm a driver of a top seven company, my lord, in a.
Oh, driver earns
So it is very difficult.
Driver earns a good amount.
He receive an amount of.
Two
rupees
school going children, how older day,
Yes, my lord.
your two school-going children,
Yes, my lord.
how old are they?
One is 7 years old and another is 8 years. One boy and one girl, my lord.
Yes.
So, my lord, moreover, the learned trial court also did not consider the independent income of the wife also, my lord.
Okay,
in
we'll
her
examine at this
petition, she
stage.
has
We are not,
stated that,
we are not very inclined. We'll only issue notice.
my lord, at this stage,
At this stage, we are not.
so much. So it is.
We are not observing also anything. If we observe reasonable, then it will affect the outcome. All right, Mr. S. Sharma,
Yes, ma'am.
Learned Counsel for the petition. First of the instant review petition is preferred against the judgment passed dated 9/7/2025, passed by the Court of Learned Principal Judge, Family Court, Kamrup at Guwahati, in FC within bracket CRL case number 353 of 2022, page 75. Post of by the state judgment, the Learned Family Court. Adjudicating on an application preferred by the respondent hearing under section 125, Code of Criminal Procedure, has directed the petitioner to pay monthly maintenance of rupees 5,000 to the respondent hearing, to the respondent's desk wife, and rupees 2,000 each to the petitioner's two minor children, with effect from the date of filing of the application. Posted. The matter is, I have heard on the Learned Counsel for the petitioner on the grounds as post of the matter require consideration, issue notice, returnable in 4 weeks. A petitioner shall take steps for service of notice upon the respondent by registered post TTD as well as by usual process. Oh, you are a worker in a cement factory.
Yes, my lord. So my
You have means to pay.
now my monthly income is 12,000, my lord. Now I have already paid him interest.
We'll examine that.
Letter part also. Deeply obliged. Item 4.
May I please, Your Lordship?
Yes.
Since this petition has been preferred for passing of the PRC case number 2843/2022 pending before the
Yes,
SDJM.
where is the FIR?
FIR is at page, Lordship, 27,
Under section 498.
498A, Your Lordship.
Yes.
If may I read it, Your Lordship, page 27.
Okay. Then what happened?
Then, Your Lordship, the case has
It
been.
was it resulted into a charge sheet.
Yes, it resulted into search it.
Where
and
is
the
that?
Cognizance has been taken place.
Okay.
Lordship, I have
Page 43,
43, Lordship.
search sheet. Yes, search sheet.
43 is the order sheet, Your Lordship.
From there, we
From
can
there, yes.
understand that it is, search sheet has been
Yes,
submitted.
Yes, Your Lordship.
Then started, the recording of evidence started.
Yes, Your Lordship. PW1, that is the informant victims, he has been cross-examined last on 8/8/2024, Your Lordship.
Okay.
Now, prior to that, Your Lordship, if may I submit, Your Lordship.
Hmm.
Prior to that, Your Lordship, both the petitioner and the informant, they have applied for a mutual divorce and that has been granted by the learned family.
Where
court.
is that?
That is, Your Lordship,
Okay, page 32.
page 32
Two,
is the joint petition, Your Lordship.
joint petition.
Yes, if Your
Hmm.
Lordship kindly takes up page number 35, Your Lordship.
35.
In the joint petition, it has been stated that the petitioner number 1 has instituted a 498A case in the year 2019 before Dispur PS, which is still pending. The same may be withdrawn at the time of same being listed before the learned season
Then
court.
granted,
That has been
divorce
granted,
granted.
divorce granted, then Annexure 3, page 38 is the order of the divorce, Your Lordship.
Now, on that basis, you want quashing of the proceeding.
Yes, your lordship, if your lordship kindly takes up the cross-examination, that is
Hmm.
page 61.
Hmm.
Cross-examination of the PW1, that is the victim come informant. Page 62, your lordship, the relevant portion is at page 62.
Yes.
Page 62, last 7 lines from bottom, it has been written in bold, your lordship. The witness has confronted that the certified copy of the joint
Yes,
petition for
Mr.
mutual divorce,
Goswami.
and it's been more than 1 year and none of the other PWs has turned up, your lordship.
Heard Mr. G. Bordole, learned counsel for the petitioner. And Mr. MP Goswami, learned
Yes.
additional public prosecutor for the respondent number 1, State of Assam. Post of the instant criminal petition under section 528 BNSS Liquidible has been preferred, seeking setting aside and quashing of
PRC
the
question.
criminal proceedings of PRC
PW1, yes.
case, PRC number, the police report case, right?
Police report case.
Police report case within bracket PRC number
2843.
2843 of 2022.
22.
Which is presently pending before the Court of Learned Subdivisional Judicial Magistrate within bracket S-1, Kamrup within bracket M at Guwahati Trial Court. Full stop. It is stated that the respondent number 2 as the informant on the issue notice returnable on DDO, data DDO. As Mr. Goswami has appeared accepted, respondent number 1, a petitioner shall take steps for service of notice upon the respondent number 2 by registered post UTAD as well as by usual process within 3 working days from today. Post of it is stated that the respondent number 2 as the informant lodged a first information report before the officer in charge, Kahilapera, Bhogodatta.
Bhogodattapur outpost, your lordship. It comes.
Before the what? Dispur police station.
Before police station.
Lodged an FIR. Lodged an FIR on 1/1/2019, which was registered as
Dispur PS case
Dispur police station, case number
27 of 2019.
27/2019 for the offense under section 498A, Indian Penal Code. First of, after investigation, the IO of the case had submitted a charge sheet finding a emergency case against the petitioner for the offense under section 498A IPC. Post of, on submission of the charge sheet, the case has been registered as PRC number 2843/2022. Post of, the petitioner on receipt of process, appeared before the learned trial court. First of, on after charges being framed, the case proceeded to the stage of evidence. Post of, the respondent number 2, that's informant. Sorry, the evidence of the respondent number 2, that's informant, SPW1, was recorded on 2/7/2024. Post of, it is submitted that subsequent to 2/7/2024, no other prosecution witness has been examined. Post of, it is further stated that in the meantime, the petitioner and the respondent number 2 dash informant being the as a husband and the wife, as the husband and the wife preferred, submitted a petition under section 13B of the Hindu Marriage Act before the Court of Learned Principal Judge Family Court, Kamrup Metro at Guwahati, Family Court for short, seeking dissolution of their marriage by a decree of divorce on mutual consent. Full stop. The said petition was registered as FC Civil Case Number 1262/2022. Full stop. In the petition, it was mentioned that mention of the case instituted under 498A IPC in the year 2019. Mention was made of this one. So it was a condition of the mutual settlement that the said case would be withdrawn. Full stop. The PW1 during her cross-examination had admitted that at the time of seeking mutual divorce, it was mentioned that the criminal case would be withdrawn. Full stop. The Learned Federal Court, by an order dated 15/5/2023, had allowed the joint petition, thereby resolving the marriage between the petitioner and the respondent number 2 dash informant by a decree of divorce on mutual consent. Full stop. Para. In the above background, in the above backdrop, an instant criminal petition has been prepared seeking the above relief. Full stop. In view of such situation obtaining the case, it is observed in the interim that the further proceedings of PSC case number presently pending before the so and so shall remain suspended till the returnable date.
8 September. Item 6.
Seeking for my PSC, Sassit Madad, along with the PSC is the PSC case is pending for my appearance stage. There is an agreement for sale, madam. It is on 26/5/2023.
Okay.
After that, my lord, due to my lord Bosundhara, my lord, the obtaining permission was sometimes delay, my lord. That my lord, on my lord, again, my lord, pleaders notice was issued on 12/1/2024.
Yes,
After
Mr. Goswami.
And
Yes,
again,
ma'am. And what I found, madam, that after the agreement, the main bone of contention is that there is no passage to the for ingress and
engage in
for the land, my lord.
my lord,
That is what the grievance of the
I can show my lord. It's
It
page,
is
my lord.
always caveat emptor.
loss.
Caveat emptor.
Loss. But
Before purchasing something, he has
Yes.
to
yes,
It's physically verified.
verify physically whether there was a road or not.
yes.
This is, and there was a reply to the legal notice.
Reply, I replied.
Come to
Page
page
48.
52.
Yes, and civil suit also there.
So, civil court is
Civil suit is already pending,
madam,
and in the reply to the legal notice,
madam. Page
they
48.
state you withdraw the false allegation.
No,
My
I have denied all the allegations. madam.
My client would refund the advance amount.
Loss.
Then there is, what is the criminality?
Loss.
And in the original document, sale deed,
No, sir.
there was a road,
There's a page
Yeah.
54, 61,
page
61.
61.
No.
No, sale deed.
But that,
Original sale deed,
original, matlab that is sale.
original sale deed.
I got silly.
I said, that is page 54. 54 or not?
No, schedule. Road, page
61,
59,
that is escalated.
59. We don't go by these diagrams. Okay. Could you stay there, proceeding
53 mile.
hard. Mr. A. Khonigar, Learned Counsel for the petitioners. And Mr. M.P. Goswami, Learned Additional Public Prosecutor for the respondent number 1, State of Assam. Full stop. The instant criminal petition under section 528B and SS has been preferred, setting aside and quashing of any proceeding is pending.
President, madam.
Where is that?
PRC case number 50,
Where
page
is
30,
that?
madam.
Where is the document? Any document?
Page 30, madam.
Page 31. Okay. Proceedings of PRC is police report case, PRC number 150 of 2025. Presently pending before the Court of Learned Chief Judicial Magistrate, Jorhat Trial Court. First up, the petitioners have also sought setting aside and quashing of the charge sheet bearing charge sheet number 34 stroke 2025 submitted on 31/01/2025 by the investigating officer in connection with Jorhat Police Station case number 2019/2024 registered under section 420/406 IPC. Post up. Issue notice returnable on so and so date. The petitioner, as Mr. Goswami has appeared, accepted. The petitioners shall take steps for service of notice upon the respond number 2 by registered post with AD as well as by usual process within 3 working days from today. Post of it is contended on behalf of the petitioner as that the petition number 1 is the owner of a plot of land described in the sale deed dated 22/12/2010 within bracket annexer G, which was purchased by her from the earlier owner of the subject plot. Subject plot likhi dibo bracket post of. The informant, the respond number 2, that's informant, entered into an agreement for sale of the subject plot with the petition number 1 by an agreement for sale on 26/5/2023 Full stop. At that time, if the informant, respond number 2, that's informant. The respond number 2, who was the informant of Jorhat Police Station case number 219/2024, had stated entirely in the FIR he lodged. In the FIR, he lodged that at the time of entering into the agreement for sale of the subject plot, he paid an advance amount. Full stop. The informant in the affair further alleged that the petition number 1 and the other petitioners had projected that on the northern side of the subject plot there was a road leading to the subject plot for ingress and egress. Full stop. The respondent respondent to this informant had lodged the affair alleging that has alleged that subsequently he found out that there was no ingress and egress to the subject plot. Full stop. A legal notice dated 12/1/2024 was thereafter served by him upon the petitioner number 1. Full stop. To that effect. Full stop. The petitioners have contended that a reply to the said legal notice was sent on 30/01/2024, asserting inter alia that the allegation made by the respondent number 2, this informant, regarding lack of ingress and egress was wrong, and there was an offer was made to refund the advance amount paid by the respondent number 2, this informant. Full stop. It has also been highlighted that the respondent number 2, this informant, has in the meantime instituted a title suit, title suit number 61/2024 before the Court of Learned Civil Judge, Jorhat, seeking recovery of money with an alternative prayer for specific performance of the contract. First of having regard to the projections so made and upon perusal of the materials placed on record, this court is of the considered view that the petitions have made out a prima facie case with regard to the interim prayer. Full stop. Accordingly, it is ordered, in the interim, that the further proceedings of PRC case number so presently pending before the Court of so shall remain suspended till the returnable date.
For admission, item number 8.
7 to give record 9. Record আছিল মই কালি বিচাৰি পোৱা নাই। Okay, 8. on this criminal appeal from jail is preferred against. The judgment is also not available. Preferred against a judgment and order dated 30/3/2024, passed by the Court of Learned Assistant Sessions Judge Karbi Anglong Difu Trial Court. In Sessions case number 63/2022, post up by the said judgment and order, comma, the trial court has convicted the accused appellant for the offenses under section 326 and section 307 of the Indian Penal Code, full stop. For the offense under section 326, comma, the accused appellant has been sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 10,000, comma, in default of payment of fine, comma, to suffer simple imprisonment for another month, full stop. For the offense under section 307 IPC, the accused appellant has been sentenced to suffer rigorous imprisonment for 7 years and to pay a fine of rupees 10,000, comma, in default of payment of fine, comma, to undergo simple imprisonment for another month, full stop. The substantive sentences are ordered to run concurrently, full stop. And the criminal appeal is admitted for hearing, full stop. Let the case records of so association's case number be called for. Issue notice returnable in 4 weeks. As Mr. Goswami, as Mr. MP Goswami learned, additional public prosecutor has appeared and accepted notice on behalf of the respondent state. Issuance of formal notice to the state respondent is dispensed with. Full stop. Single mess, no? To represent, to represent the accused appellant in the instant appeal. This court, DMC proper, to appoint Sri Dixit Gogoi from the panel of amicus curiae. Amicus curiae. First one. Dixit Gogoi, Mr. Gogoi. Learned counsel পিছত নামৰ পিছত registry to notify the name of Mr. Dixit Gogoi, learned amicus curiae in the cause list, and he shall be furnish the necessary case papers within a period of 1 week from today.
Item 9.
Team আগৰটোৰ নিচিনাই হ'ব, right from jail, huh? Against the judgment dated 30/01/2024 and an order on sentence dated 2/2/2024. Special Judge, NDPS, Karbi Anglong at Difu Trial Court, a special court. NDPS case number 12/2022 by the judgment and the order on sentence, the accused appellant. Has been convicted for the offense under section 21 within brackets small c of the NDPS Act, and he has been sentenced. To undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1 lakh, in default of payment of fine, to undergo simple imprisonment for another 6 months. He admitted for hearing, case records, issue notice, sub same, naam to early. Listed Aruna Pukoi, ARUNAV.
Item 10.
It's him appeal from jail, huh? Judgment dated 35/2024, an order on sentence dated 1/6/2024. Court of Sessions Judge Hibohagar, Trial Court. Sessions case number 43 within bracket S-N of 2023. By the judgment in order it is so the trial court has convicted the accused appellant for the offences under section 427, section 323, section 436, and section 506 of the Indian Penal Code. Poster. এতিয়া এইটো ডেট এটা দি দিব ইস্যু নোটিস রিটার্নেবল এটা ডেট দি দিব
10 September.
The highest sentence is passed. The highest sentence of simple imprisonment. All the sentences are ordered to run concurrently. For the offense under section 436 IPC, the accused appellant has been sentenced to, sentenced to undergo rigorous imprisonment for 5 years and to pay fine of rupees 5,000. Nalang, 4 weeks till 4 weeks till 4 weeks. With default stipulation. Post of lesser sentences. Lesser terms of sentences have been passed for the other offences. Okay, you may repeat admitted for hearing by লিখে দিব। Name. Sarfaraz Nawaz লিখে দিব। এর নামটো আছে লিষ্টত।
Item 11.
ভিতৰতে আছে। Judgment and order dated jail, from jail, 30/11/2023. Additional Session Judge Shibahagar. Trial Court. Sessions case number 225 within bracket S of 2013. Appellants, Appellants. Admitted for hearing. No, they sorry. By the state so and so judgment, the accused appellants have been convicted for the offense under section 304B, read with section 34 of the Indian Penal Code. And they have been sentenced to undergo rigorous imprisonment for 7 years each and to 7 years each. Person admitted for hearing. Yes, of course. By hearing, it is consolation. Topon Ranjan Deuri.
Item 12.
Appealing. Jail, Judgment. An order dated 25/3/2025. Special Court, Soraideo Kunari, within bracket Special Court. In special within bracket POXO case number 02/2021, which arose out of Punari Police Station case number 254/2020 by the judgment and order dated so and so, the special court has convicted the accused appellant for the offense under section 4 within bracket 1, POXO Act, and he has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 25,000, come in default of payment of fine to undergo simple imprisonment for another 6 months. Admitted for hearing. Yes, courts. As Mr. Goswami, additional public prosecutor has appeared and accepted notice on behalf of the respondent, State of Assam, issuance of formalities. and dispense which, proceed. The office to send notice upon the effective direction from the action. Informant. To the informant in terms of the practice direction so and so. Our additional public prosecutor is to obtain a service report from officer in charge so and so. Panel. Single bench. Panel name 2. Okay. Right. Suroji does the duty.
For orders, item 13.
But you here the appeal has already been admitted and the information has already appeared. So may I pray for taking the IN number 659 of 2025?
Okay. Taken.
So may I pray for suspension of the impending sentence?
Mr. Deori, you've been appointed in one. And I think which one? Ah. 11, item 11. Yes.
Yeah, the conviction, my lord, of the appellant is under for the offense under section 363 IPC, my lord.
What is 363?
There for kidnapping, my lord.
Huh?
Kidnapping.
Kidnapping.
In yes, law.
IPC.
And maximum punishment is up to 7 years one. My lord, yeah, the trial court convicted the appellant for 4 years only, my lord.
Only 4 years.
Only 4 years and a fine of rupees 10,000, my lord. In default to payment of the fine, my lord, and
You paid the fine.
imprisonment for
You paid the fine.
no, my lord. The appellant is in confinement, my lord. Since the date of conviction, my lord.
Yes, Mr. Das.
I have no objection.
Heart. Mr. R. Hussain. Learned counsel for the appellant. Mr. R. Kaushik, learned additional public prosecutor for the opposite party, that's respond number 1, State of Assam. And Mr. H. Das. You are engaged counsel or amicus?
Yes, sir.
Okay. Learned counsel for the respondent opposite party, that's respond number 2. Post of the instant application under section 430 within bracket 2 Bharatiya Nagorik Purokha Honita 2023 has been preferred seeking suspension of execution of the sentence passed against the appellant and for his release on bail. Full stop. The applicant as the appellant has preferred the accompanying criminal appeal, criminal appeal number 223/2023. And criminal appeal has already been admitted for a hearing on 24/6/2023. Full stop. Para. The applicant has preferred the criminal appeal against a judgment dated 28/5/2025 and an order on sentence dated 3/6/2025 passed by the Court of Learned Additional Session Judge Special Judge, POCSO, Kamrup M at Guwahati, within bracket the Special Court in sessions within bracket special bracket close case number 192/2023. First off. in the course of the trial, the special court framed charges against the appellant under section 366, IPC and section 4, POCSO Act. Full stop. While delivering the judgment and order dated, the impugned judgment and order on sentence, the appellant has been convicted for the offense under section 366 IPC, and he has been sentenced to undergo rigorous imprisonment for 4 years and to pay a fine of rupees 10,000, in default of payment of fine, to undergo simple imprisonment for 6 months. Full stop. The special court had acquitted the appellant from the charge under section 4 POCSO Act. Full stop. Para. The learned counsel for why you should be ground.
Ground lordship. Your lordship, kindly say paragraph 4 of the IN number 6591.
In the
During the course of trial, my lord,
it has been it has been highlighted that the victim, while deposing as PW1, during cross-examination, disclosed that she voluntarily went along with the appellant. Full stop. The IO in his testimony given as PW3, stated that the victim eloped with the appellant had also eloped with the appellant earlier. Full stop. Having regard to the projections so made on this court is already considered due to the petition appellant has made out a prima facie case, full stop, for suspension of execution of the sentence passed against him. Full stop. It is accordingly ordered that pending disposal of the appeal, the applicant, the execution of the sentence passed against the applicant appellant shall remain suspended, and the applicant appellant shall be allowed to go on bail 10,000 on COT, rest satisfaction of the trial court.
deeply obliged.
Appeal, hello?
Item 14.
আই আছে নেকি?
এটা বন্ধ করে দিও। নিপা ওলাই আছে। নিপা ওলাই আছে।
Item 15, criminal revision.
Criminal revision petition. Yes.
Your
Busy
lordship,
nahi?
PC.
VC.
Your voice is not coming. You are not audible.
Your lordship,
Yes.
yes, lordship. I am Advocate Malaya Ghosh from Sribhumi district. I am petitioner in person of this criminal revision petition. My lord, I filed this petition. I filed this petition on
Okay, delay.
2nd May 2025,
So
and
11 days delay.
yes, 11 days delays, and
Okay,
on
we have
the-
to issue notice then. We are issuing notice. Hard
Yes,
miss.
yes, my lord. And
M. Ghosh.
another prayer is, your lordship, please stay the proceeding before the trial court till disposal of this criminal revision
No,
petition.
if the delay is not condoned, how can it be?
My prayer is for admission of this condemnation petition, and after that, stay the proceeding.
Madam, you know, it seems that you are a practicing advocate.
Yes,
Then you know, without condoning the delay,
yes,
no
lordship,
substantive order can be passed.
lordship,
Then we have to issue notice.
lordship.
If you want, we can also give Dusty also provision. Serve him by Dusty. Hard Miss M. Ghosh, petition in person, because of the instant application under Section 5 of the Limitation Act 1963 is preferred seeking condonation of delay of 11 days, which period delay is stated to have occurred in preferring the accompanying criminal revision petition against an order dated 21/1/2025 passed by the Court of Learned Additional District and Sessions Judge Sribhumi in Sessions Case number 34 of 2021. Issue notice returnable on so and so date. The applicant shall take steps for service of notice upon the respondent should upon the opposite party by registered post with SD as well as by usual process within 3 working days from today. In addition, as prayed for Dusty. Right? Compliance affidavit.
5/9, 5th September. Item 16.
What extension of fluency?
My lord, earlier, I ordered dated 20/02/2024. The petitioner was directed to appear before the trial court within 10 days, my lord, and the NBWA issued against the petitioner was suspended till that period, my lord.
Mm-hmm.
Our order is at page 12, my lord.
Order is at page 12.
Page 12, my lord. Starts from page 11, my lord. 11 portion is at page 12.
(22) 2024.
24.
What offense you are facing?
My lord, prosecution under section for offense punishable under section 6, 365 of
6 POXO Act.
POXO Act, my lord. 6 POXO Act and 365 of IPC, my lord.
Yes. Then, since then, what you are doing?
My lord,
Since February 2024, we are in August 2025.
according to the petitioner, my lord, he was suffering from sleep disc and other ailments, my lord. That is why he could not appear before the trial court, my lord. The next date is fixed on 22nd of this month, my lord. My limited prayer today before this honorable court is to
So what kind of explanation you have given? Some tablets.
some tablets and medical certificates are also there, my lord.
Page 16 is the medical certificate, my lord.
That is not very satisfactory. August 2024. We cannot stretch our
I understand.
jurisdiction to such an extent. You said, oh, since August 2024, you are suffering from sleep disk. Right.
Pardon, my
But
lord?
this order
Yes, my lord.
was passed on February 2024. So in between 6 months. And when you came, it was 10 days only.
It was 10 days only.
Hmm.
It was 10 days. Admittedly, it was 10 days only, my lord.
We cannot stretch our hand to such an extent for a person who is facing the charge under POCSO.
My lord. My lord, here, my lord,
We are not very inclined to
the,
do so. Once you have approached,
yes, yes.
court has extended the privilege to the maximum.
Yes.
Then you disobeyed that order because of your undertaking. You said you will be appearing within 10 days. Court has granted you 10 days. Then thereafter, no explanation. You have to face the consequence. We are not going to stretch our hand beyond a limit.
That is there, my lord.
We don't find any explanation, logical explanation.
And-
Your certificates, clip this, we can understand, but still it was from August 2024.
24.
No explanation for 6 months. How can we extend the absolutely no explanation?
My lord, here, in this case, my lord, what?
This will be too much.
Well,
This will be too much.
if your lords may kindly allow me, madam. Here, in this case, my lord, the victim is the sister-in-law of the
Whatever, we are not into the merits.
my lord.
Merit is for a trial court to decide.
Well.
Prima facie, you are facing a charge under POCSO.
Yes, yes, primary.
And there is no explanation since the order.
Yes.
Order is too much. Had it been 1 month, 2 months, yes, we can understand. Absolutely nothing. This is apparently an effort to abuse the process. Absolutely no explanation.
No.
Sleep disk you have obtained,
Yes.
medical, okay, but that medical is also not proper, leaving a huge gap of 6 months.
Perhaps, my lord, I could not be able to satisfy this honorable court by giving proper explanation in my petition, my lord.
We are dismissing it. We cannot stretch in the name of interest of justice. You have to face the consequence because once you have approached,
My lord.
made an undertaking before the court, and you are disobeying the order of the court, we don't find any explanation. And we'll impose cost also.
My lord, cost part, my lord, I humbly pray before this one.
Heard Mr. M.K. Sharma,
MK Sharma, my lord.
Learned Counsel for the Petition. Yes, Mr. Kosik.
Going by the, your lordship has already pointed out, it is from 12/8/2024. 6 months he was silent. Secondly, my lord, this certificate was issued only on 25/2.
Let us see earlier what was the conduct. Let us see, the petition is here. Oh, earlier, 1, 2, 3, 4, 5, 6, 7, 8, 9. Defaulted on 9 occasions. Then you approached. Then granted you liberty for 10 days.
Earlier part. I
Got
have-
the, armed with that order, you were there since February 2024. 6 months, no explanation. Somehow you have got a medical document from August 2024. And that was also issued on when?
20
April,
May,
May,
medical certificate.
medical service.
Prescriptions are there, my lord.
Hmm.
Page 14, my lord, 12/8/2024.
No, 6 months is too much. Earlier 9 occasions. When you approached by the criminal petition, 9 occasions, NBW issued. You have to face that because there is no chance. Heard, Mr. M.K. Sharma. Learned counsel for the petitioner and Mr. R.R. Kosik, learned additional public prosecutor for the respondent. State of Assam. Post of the instant criminal petition. Instant interlocutory application is preferred by the petitioner with a prayer to extend the operation of an order dated 20/02/2024 passed earlier in a criminal petition preferred by the petitioner, criminal petition number 129/2024. Full stop. It is noticed that the petitioner had earlier approached this court invoking inherent powers of this court under Section 482 Code of Criminal Procedure 1973, seeking quashing of an order dated 3/11/2022 and the subsequent orders passed by the Court of Land Special Judge North Halmara, Abhayapur. Abhayapuri or Abhayapur?
My lord, it should be Abhayapuri, my lord.
Abhayapuri, within like a special court. In the proceedings of, in the course of the proceedings of special within bracket P, case number 78 within bracket J, stroke 2022. Full stop. The occasion to approach the court earlier arose when the Land Special Court by orders dated 3/11/2022, 16/12/2022, 10/2/2023, 33/2023, 22/5/2023, 6/7/2023, 23/8/2023, 10/10/2023, and 15/12/2023. Issued non-bailable warrants of arrest to secure the appearance of the petitioner in the proceedings of special P case number 78 J stroke 2022. After submission of a charge sheet against the petitioner for standing in the trial for the offense under section offenses under section 6 Protection of Children from Sexual Offences Act and section 365
365 along read with section 376
Oh.
subsection 3
section 376
subsection
and
3.
section 365 of the Indian Penal Code. Full stop. You want implement?
Yes, sir.
Mr. Taludar, you have preferred the
A criminal
criminal
petition.
petition, seeking passing or something.
That has been
Yeah,
paid.
any objection?
No, I don't have any objection. They can assist the people.
Ah. No, where? The criminal petition is prepared for what?
For infringement. They want to infringe the party.
By way of this criminal petition, these are assailing the impugn order
Quashing, that is for quashing.
for quashing.
Quashing on the proceeding.
Hmm. No, he has independent right, perhaps.
Yeah.
He has independent right.
Let-
Yesterday
Because
I
he
was.
was another victim, yes, why, that is 2Y of the BNS.
টেবুলত আছে ওপৰতে মই কালি পঢ়ি আছিলো কিবা এটা
Recently, one judgment has come.
No, old one. Old one.
The victim has got right. That is,
He is informant.
he is informing them.
Heard Mr. T. Dewey, learned counsel for the applicant. Mr. MP, okay, Mr. D. Talukdar, learned counsel for the opposite party number 1, 2, and 3. And Mr. MP Goswami, learned additional public prosecutor for the opposite party number 4, State of Assam. Full stop. The instant interlocutory application is preferred by the applicant seeking impleadment. Seeking his impleadment in as respondent number 2 in criminal petition number 687/2025, preferred by the opposite party number 1, 2, and 3 before this court. Full stop. The said criminal petition is pending as on date for consideration. Full stop. The criminal petition, criminal petition number so and so, has been preferred by the opposite party number 1, 2, 3 as the petitioners to assail an order dated 21/5/2020 passed by the Court of Landed Subdivisional Judicial Magistrate within bracket S number 2 as Kamrup M at Guwahati, whereby cognizance was taken against the said petitioners under sections 201/304A, Indian Penal Code in PRC number 971/2022. Full stop. ঠিকে আছে নেকি এটা চাওঁ কেনেকে He is not required to be made a party,
Not required to.
but he can.
He can come.
As the accused persons have approached the High Court for quashing the criminal proceedings initiated at the instance of the applicant, the accused persons, Full stop. In JK International versus State Government, so and so. It has been observed as paragraph 8. Paragraph 8 or bracket to bracket. Moreover, Mr. Talukdar, Land Counsel for the opposite party number 1 to 3 has fairly submitted that he has no objection if the applicant is impleaded as per number 2 in the connected criminal petition. Full stop. In view of the above, the instant interlocutory application is allowed resti to implead the applicant hearing as respondent number 2 in the connected criminal petition number so and so.
Much.
No, who will give? Talukdar. Mr. Talukdar, so has to submit amended cost title in terms of notification so within 3 working days from today.
Item 18.
Lordship, the
Yes,
IA is preferred for suspension of NBWA, Your Lordship. The criminal-
NBWA,
Yes, Your Lordship. Criminal revision was preferred against a conviction in 138 NI Act case, Your Lordship. Notices were issued. However-
138 NI case.
Yes, Your Lordship.
What? Additional chief judicial magistrate,
9 lakh.
additional judicial magistrate, criminal appeal. So
Criminal-
concurrent finding of act.
Yes, Your Lordship.
Then
It was reduced, Your Lordship. The fine.
reduce, whatever.
There
What is
was,
the term of sentence?
fine in default, 6 months imprisonment, Your Lordship.
12 lakh,
It was reduced to 9 lakhs.
9 lakh.
And in default, it was 6 months imprisonment.
Correctly,
Yes, sir.
issue notice sole respondent.
Lordship,
This thing has not yet been admitted.
no, Lordship, notices were issued.
Ah.
In the meantime, since I did not appear before
Ah.
the trial court, Your Lordship, NBWA was issued, which is at page number 7, Your Lordship. Page number 8 of the IA.
Mr. Mukherjee will decide it on Tuesday, but you have said why you are not paying subject to deposit then everything.
Lordship,
You are an assistant professor.
yes, Your Lordship.
Bijora Koinna Mahavidyalaya.
Yes, Your Lordship. My submission, my ground in the case is that I borrowed 4 lakhs, which I returned, Your Lordship.
Oh, but
Was- that is on the
there
direct,
are
Your Lordship.
now concurrent findings of fact. 2 judgments.
Yeah.
You cannot avoid until it is,
NBW, Lordship,
it is a natural consequence. Unless it is suspended,
Lordship.
it will be taken into custody. Then this court can suspend, but in view of concurrent finding of fact and in view of provisions of section 148A NI Act, this court will exercise discretion. And discretion is relatable to
Deposit of.
a deposit of some amount. Think it over, 9 lakh. You are an assistant professor. At least presumption is that you have the capacity to pay. Right? Tuesday, we'll decide. Talk with your
Right,
client. It may be 25%.
I'll talk.
Within a period of 45 days, then NBW will be suspended. Right?
Hmm.
BJ Mukherjee. Mr. Gusami is there?
I'm not here.
Lordship. Notices are
Is
awaited.
present. Okay. On the request of Mr. Mukherjee, this is the case on Tuesday. Talk with your client.
Item 19.
There is no representation on behalf of the applicant today on call. In view of such a non-representation, let the case come up for answer of justice. Be listed after a week.